Supreme Court shuts down the executive branch in sweeping ruling without a hearing, barring all enemy alien deportations, guaranteeing open borders forever. Hello, this is Robert Romano, Executive Director with Americans for Limited Government and Americans for Limited Government Foundation. Hit that subscribe button. Today, we're going to be talking about a Supreme Court order that came down in the middle of the night on April 19th. As you know, everyone's celebrating, the Easter holiday over the weekend. Supreme Court comes in and says no more Alien Enemy Act deportations until we tell you to, President Trump. This was presumably about a 7-2 order by the Supreme Court. Only Justices Samuel Alito and Clarence Thomas were dissenting. So we have to assume it was 7-2 to say, yes, stop, halt all deportations under the Alien Enemy Act until the court says so. Even though, Congress had obviously enacted this statute back in 1798. And otherwise, the executive branch has broad authorities to deport illegal aliens in the normal course of business. You have expedited removals, for example, under a 1996 statute that Congress enacted. And there's about 20,000 plus expedited removals under the 1996 statute every single year that are not being suddenly held up because of some emergency order by the Supreme Court. And they've been, the executive branch has been doing expedited removals. In fact, the Supreme Court upheld the expedited removal process in 2020, stating that it was not a habeas corpus, that was being suspended by the expedited removals under the basis, and we'll get to this case, under the basis that we're not talking about detention of illegal aliens. We're talking about the removal of illegal aliens. And that was a 7-2 decision by the Supreme Court that upheld the expedited removal, saying that, you can do these. Now, under certain provisions of, inadmissibles under 8 U.S. Code Section 1182, if you're found to be a terrorist by the Attorney General, you can be removed under 8 U.S. Code Section 1225. And that can be without a hearing whatsoever. And these provisions have been, were expanded under the Patriot Act in 2001, but they go back to, in fact, rules of under 1990 immigration statute. So we're talking about laws that Congress has enacted, whether it's the Alien Enemy Act or these expedited removals beginning in 1996, or the classification of terrorists being inadmissibles under a 1990 statute. These are all duly enacted by Congress, and the president should be able to enforce the laws. The president has declared a national border emergency. He has deployed under the emergency the U.S. military to the southern border. We've seen that illegal immigration is ground down to a halt. Almost barely 11,000 a month now. It used to be 180,000 a month under Joe Biden, but now it's down to 11,000 border encounters every single month under the first 2 months of the Trump administration. And so Trump has militarized the situation. He's declared the national emergency. He's invoked the Alien Enemy Act, although he need not. He can just do expedited removals under 8 U.S. Code Section 1225. And I think that's likely the basis that, we're going to end up determining what's going on with this. But the habeas corpus, I want to go over that too, because Congress clearly has the power to suspend the writ of habeas corpus, which could result in indefinite detentions. And you can argue that's exactly what it did with the Patriot Act. So are we to believe that under our current laws, the president of the United States can take an alien enemy or just an alien, someone who came here illegally, and hold them indefinitely, to detain them indefinitely under the Patriot Act, but he can't remove them? Are you kidding me? That seems to be where we're headed right now. Seeing the Patriot Act and the indefinite detentions. I mean, you have the Hamdi v. Rumsfeld, and you do eventually get around to the idea that there should be military tribunals for those who were captured overseas in the war on terrorism and then were detained at Guantanamo Bay. It's like, oh, eventually you have to have a military tribunal for that person. etc. But we're not talking about indefinite detention. We're talking about expedited removals of illegal alien enemies and people who the president has declared to be terrorists. So first I wanted you to hear from Pam Bondi. She's addressing the Kilmar Abrego Garcia case in a press conference. First, we'll hear from the reporter who's asking the question, and we'll hear what she has to say about this. I think it's worth listening to. Let's see, make sure the volume's up. Good.
Big topic over the past few weeks, Kilmar Abrego Garcia in Maryland. He's in a prison now in El Salvador. He was sent there. You insist, the president, everybody in the administration insists that he is MS-13. It appears that there's not going to be any sort of trial. He's not going to come back. DHS said he would be arrested and redeported if he comes back. Why not show the American people the evidence that he's MS-13 so they can make an informed decision? And that goes the same with this Henry Josue Santos, who was picked up in Virginia, who is now presumably going to be deported as well. Why not show the public the evidence?
Well, he is an illegal alien who has been living illegally in our country from El Salvador. ICE testified, an immigration judge ruled he was a member of MS-13. An appellate judge ruled he was a member of MS-13. Hard stop. He should not be in our country. He was deported. They needed one additional step in paperwork, but now MS-13 is characterized as they should be, as an FTO, as a foreign terrorist organization. So he is not coming back to our country. President Bukele said he was not sending him back. That's the end of the story. If he wanted to send him back, we would give him a plane ride back. There was no situation ever where he was going to stay in this country. None. He would have come back, had one extra step of paperwork, and gone back again. But he's from El Salvador, he's in El Salvador, and that's where the president plans on keeping him.
The evidence, we're not going to see the evidence.
So there's the Attorney General, Pam Bondi, saying that Kilmar Abrego Garcia, he's in El Salvador now. That's where he came from. He's from MS-13. He's a illegal alien, and he's of a foreign terrorist. So he's gone. They're not going to bring him back in here. And in fact, under the statutes we're about to go over here, you'll find that he's inadmissible. You couldn't even bring him back in if you wanted to, because he's foreign terrorist. And you would find that, oh, well, here's the foreign terrorist. Oh, wow, he's back in the country. He's inadmissible to come into the United States under the laws that Congress established. So let's go over my piece here. Supreme Court shuts down the executive branch. In the dead of night, the Supreme Court on April 19 entered a sweeping order barring all further deportations by President Donald Trump and the federal government under the 1798 Alien Enemy Act. And this is a very short order. There's before the court an application on behalf of a putative class of detainees seeking an injunction against their removal under the Alien Enemy Act. The matter is currently pending before the Fifth Circuit. Upon action by the Fifth Circuit, the Solicitor General is invited to file a response to the application before this court as soon as possible. The government is directed not to remove any member of the putative class of detainees from the United States until further order of this court. Justice Thomas and Justice Alito dissent from the court's order. Statement from Justice Alito to follow. And we do have that dissent from Justice Samuel Alito. Thomas joins the dissent. He goes through the various aspects of the processes that are not being followed here. And I'll just skip to the end here. In sum, literally in the middle of the night, the court issued unprecedented and legally questionable relief without giving the lower courts a chance to rule, without hearing from the opposing party. Within 8 hours of receiving the application, with dubious factual support for its order, and without providing an explanation for its order. I refused to join the court's order because we had no good reason to think that, under the circumstances, issuing an order at midnight was necessary or appropriate. Both the executive and the judiciary have an obligation to follow the law. The executive must proceed under the terms of our order, Trump v. JGG, that was a few weeks ago, per curiam, and this court should follow established procedures. So Samuel Alito is clearly upset about this midnight order by the Supreme Court, which suspends deportations under the Alien Enemy Act. Any such that the president had teed up under his national emergency declaration, declaring the Tren de Aragua and other cartels to be terrorist organizations, including MS-13. All of that goes out the window if you're trying to deport under the Alien Enemy Act. But as we shall see, there are other statutes that the president can likely utilize to go and remove the alien enemies or the terrorists or the drug cartels that have been so declared. The apparent 7-2 ruling, Justices Samuel Alito and Clarence Thomas dissented, effectively blocked President Trump from acting on his March 15 proclamation that Venezuela and its proxies, including the criminal drug cartel terrorist game Tren de Aragua, are perpetrating, quote, perpetrating, attempting, and threatening an invasion or predatory incursion against the territory of the United States. And here was the invocation of the Alien Enemies Act regarding the invasion of the United States by Tren de Aragua on March 15, 2025. And this is allows for, the restraint, regulation, and removal of the alien enemies. Whenever there is a declared war between the United States and any foreign nation or government, or any invasion or predatory incursion is perpetrated, attempted, or threatened against the territory of the United States by and for any foreign nation or government, the president makes public proclamation of the event. All native citizens, denizens, or subjects of the hostile nation or government being of the age of 14 years and upward, who shall be within the United States and not actually naturalized, shall be liable to be apprehended, restrained, secured, and removed as alien enemies. So if you're not a resident of the United States, if you weren't brought in here legally, you didn't come here, you don't have a green card, you're here illegally, and you've been declared an alien enemy as Tren de Aragua, and anyone from Venezuela, the president decides, can be removed on that basis as an alien enemy, or anyone else who's been named an alien enemy by the president can be removed under this basis. And so the order is applying to the alien enemies, specifically for those from Venezuela that are now being removed. And, as the Kilmar, Abrego Garcia, those are terrorist organizations as well. And I believe that a separate statute will actually apply to them. So we're going to deal with both the case of the alien enemies as it pertains to the Supreme Court's order, and then also the Kilmar, Abrego Garcia case, which is MS-13, and I believe comes under a different statute for those the terrorists that the president has declared for Tren de Aragua or MS-13 or any of the other criminal drug cartel gangs that are operating in the United States, are bringing fentanyl into the United States, are killing hundreds of thousands of Americans. I believe that the president's going to be well within his rights to remove those people under either of those the two statutes. And I've covered it's going to come under the expedited removals under 8 U.S. Code Section 1225, and also those inadmissible under 8 U.S. Code Section 1182. So jumping back to my piece here, the president certainly has power to declare that there is such an invasion under 50 U.S. Code Section 21, enacted by Congress in 1798. And President Trump has thus far treated the invasion as a military matter under his January 20th border emergency declaration. And we have that right here. On January 20th, the president declared a national emergency under the southern border, which allows for him to activate the U.S. military, which he has done under 10 U.S. Code Section 12302, Ready Reserve. This allows for not more than 1 million members of the Ready Reserve may be on active duty. And in a time of national emergency declared by the president, an authority designated by the secretary may, without the consent of the person's order, without the consent of the persons concerned, order any unit or any member not assigned to a unit organized to serve as a unit in the Ready Reserve under the jurisdiction of the secretary for active duty. And not for more than 24 consecutive months. But clearly the president is taking this deadly serious. He is activating the U.S. military onto the southern border of the United States to deal with the emergency. He's also authorized construction under 50 U.S. Code Section 1631 and 10 U.S. Code Section 2808 for the finishing of the construction of the southern border wall. And we have that here too, 2808 construction authority in the event of a declaration of war or national emergency. So under the national emergency, and this has already been litigated. The president did this in 2019. He said, Congress hasn't given the money to build the border wall, but we have lots of money for national defense. So I'm going to reprogram some of those funds to go to the construction of the border wall. And he's done that. In 2019, it was upheld by the Supreme Court, and now it's being done again under the national emergency that Trump has declared here. And this is, again, a law that Congress has enacted under national emergencies. You can declare a national border emergency if there's an invasion of the country. You have all this fentanyl being pushed across the border by terrorists. If the president makes that determination that there's an invasion, then he can do what he has to do under the National Emergencies Act to declare the emergency, to say that there's an invocation of the Alien Enemies Act, to put the military out there, to build the border wall. Now continuing with the piece. Trump also declared Tren de Aragua, MS-13, and other criminal gangs, drug cartels as terrorist organizations on January 20th by executive order. I believe we have that here as well, designating cartels and other organizations as foreign terrorist organizations, and especially designated global terrorists. And this is done under 8 U.S. Code Section 1189, designation of foreign terrorist organizations. The president, under laws that Congress established, can say, hey, those Tren de Aragua guys, those MS-13 guys, those drug cartels and criminal gangs that are pushing fentanyl across the border, killing hundreds of thousands of Americans, those are terrorists. And so he is so declared. He's following the law. He is enforcing the law. And oh, by the way, the 1952 and 1965 Immigration and Nationality Acts never repealed the 1798 Alien Enemy Act. And we look at the 1952 statute here. I have it pulled up. You can see that it's implicitly an invoked and accepted enemy aliens as being permitted to enter the United States. Quote, the following classes of aliens shall be ineligible to receive visas and shall be excluded from admission into the United States: aliens who have been arrested and deported or have been removed as alien enemies. So when they enact the Immigration and Nationality Act of 1952, they are clearly not repealing the 1798 Alien Enemy Act. And while the 1965 Act did amend this provision of 8 U.S. Code Section 1182, here's the 1965 Immigration and Nationality Act amendments, it didn't repeal the 1798 Alien Enemy Act. All it did was revise the section that I just quoted from the 1952 Act. It does, however, it no longer mentions alien enemies as being inadmissible, but it still contains very similar provisions specifically for aliens designated as terrorists in subsection A3B, as the president has done. And here's section 8 U.S. Code Section 1182, inadmissible aliens, and you have security-related grounds. An alien who a consular officer or the attorney general knows or has reasonable grounds to believe seeks to enter the United States to engage solely, principally, or incidentally in any activity to violate any law of the United States relating to espionage or sabotage, or to violate or evade any law prohibiting the export from the United States of goods, technology, or sensitive information, any other unlawful activity, or any activity a purpose of which is to the opposition or to control or overthrow of the United States by force, violence, or other unlawful means is inadmissible. Terrorist activities, any alien who has engaged in terrorist activity, who the attorney general has reason to believe is engaged or is likely to engage after entry in any terrorist activity, has under circumstances, indication, and intention to cause death or serious bodily harm, incited terrorist activity, is a representative of a terrorist organization or political, social, or other group that endorses or espouses terrorist activity, is a member of a terrorist organization, or is a member of a terrorist organization, unless the alien can demonstrate by clear and convincing evidence that the alien did not know that he was a member of the terrorist organization, endorses or espouses terrorist activity, or persuades others to endorse or espouse terrorist activity or support a terrorist organization, has received military type training on behalf of a foreign terrorist organization, is the spouse or child of an alien who is inadmissible under the subparagraph if the activity causing the alien to be found inadmissible occurred within the last 5 years, is inadmissible. And any alien, an alien who is officer, official, or representative, spokesperson of the PLO is also considered to be someone who is engaged in terrorist activity. But clearly, inadmissibles include anyone who, poses a national security threat, is violating the law, or is engaged in terrorist activities. And these organizations, MS-13, also the Tren de Aragua, they are all been declared to be terrorist organizations. So the president has the power to do that, to designate the cartels and other organizations as terrorist organizations under 8 U.S. Code Section 1189. And then those people are inadmissible aliens under that very provision there. And this has been variously amended over the years, the inadmissible aliens. There's several that came in 2001 under the Patriot Act, but the expedited removals that we want to talk about in my piece here actually come under 1996 Illegal Alien Act. That's passed under the House Republicans, Senate Republicans, and Bill Clinton as president signs it into law as a part of the omnibus bill. So we'll get to that, though. However, despite the president militarizing the operation and naming the terrorist targets as it relates to the invasion that he singularly has the power to proclaim and to interdict, the Supreme Court has suspended enforcement of the law under the Alien Enemy Act, ostensibly so that every invader and every illegal alien being targeted by President Trump for mass deportation. Let's just cut to the chase. This is about preventing Trump from implementing his removal program writ large. He's promised mass deportation. So the Supreme Court's going to say, nah, you're going to have a hearing for every one of the 15 to 20 million illegal aliens that you're trying to remove from the country. And they want to provide a due process hearing under the Fifth Amendment. In other words, regardless of whatever laws Congress has already passed to see to the expedited removals of illegal, inadmissible aliens by the executive branch, the Supreme Court appears to be setting the predicate that, as a constitutional matter, all immigration laws allowing for expedited removals without hearings are now unenforceable. I mean, that's what the Alien Enemy Act does. It says, oh, you can't have these expedited removal under the Alien Enemy Act. Well, what about under Section 8 U.S. Code Section 1225 under the 1996 Illegal Alien Act? All wars which deprive people of their lives without due process hearings, too, via the use of force, even when Congress did authorize it, must they be suddenly unfightable too? I think, how, if you can't remove somebody without, the due process, when Congress explicitly provided for expedited removals under the law that President Trump is following, then what can you even prosecute a war? What if there's an invasion? As Trump is saying, what if the military on the southern border right now gets into a battle with the drug cartels? Do they have to have hearings before they can act on the intelligence that they're about to be attacked, or that there's an enemy position, we need to attack it? It seems that might be the case. But why stop at removals? What about those deemed inadmissible under 8 U.S. Code Section 1182, who are barred from even entering the United States without any hearing whatsoever, just an executive determination that they do not meet the criteria for entry into the United States? For example, under 8 U.S. Code Section 1225, subsection C, it states that inadmissible aliens can be immediately removed. So here's 8 U.S. Code Section 1225, inspection by immigration officers, expedited removable of inadmissible arriving aliens, and referral for hearing. and you jump down here, removal of aliens inadmissible on security and related grounds, removal without further hearing. If an immigration officer or an immigration judge suspects that an arriving alien may be inadmissible under 8 U.S. Code Section 1182, inadmissible aliens under the security grounds and related grounds. If so, then that person can be removed without further hearing. Order the alien removed, subject to review. Report the order of removal to the Attorney General and not conduct any further inquiry or hearing until ordered by the Attorney General. Review of order. The Attorney General shall review orders under paragraph 1 if the Attorney General is satisfied on the basis of confidential information that the alien is inadmissible under, that means classified information, other than the clauses stated. Then after consultation with appropriate security agencies of the United States government, concludes that disclosure of the information would be prejudicial to the public interest, safety, or security, the Attorney General may order the alien removed without further inquiry or hearing by an immigration judge. This was passed in 1996. This is the public law. Let's see here. I think I have it right here. Yes. This is the, be it enacted by Senate and House assembled, that the following, this is an omnibus appropriations bill. And in that you have underneath it inspection of aliens, expedited removal of inadmissible arriving aliens, referral for hearing, revised section. So this inspection of this section of the omnibus bill was passed in 1996, and it's actually been upheld by the Supreme Court in 2020. This was a case, Department of Homeland Security v. Thurasium. It's the Illegal Immigration Reform and Immigrant Responsibility Act provides for the expedited removal of certain applicants seeking admission into the United States, whether at a designated port of entry or elsewhere. 8 U.S. Code Section 1225. An applicant may avoid expedited removal by demonstrating a credible fear, significant possibility. An applicant who makes this showing is entitled to full consideration of an asylum claim. An asylum officer's rejection of a credible fear claim is reviewed by a supervisor. But again, all of this can be overridden in the Section 1225 if the Attorney General deems it so, that there's, if the alien is inadmissible under subsection A, B, or C of Section 1182A3 of this Title 8, and that's the security grounds, inadmissible alien security grounds, national security or terrorist member, they can just say, hey, the credible fear, no, you're a terrorist, you get the heck out of this country. And so in any event, the Supreme Court upheld this as not having to do with the habeas corpus. And so we're going to held the as applied this Illegal Alien Act of 1996, which provided for expedited removals, does not violate the suspension clause of the Constitution. This is Article 1, Section 9 of the Constitution, Clause 2. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. So even if it did apply, the president has declared that there's an invasion under the Alien Enemies Act. He did that already. And so the president has determined under 5 U.S. Code Section 21 that there is an invasion of the country. So even if the writ of habeas corpus did apply, the Supreme Court said that these expedited removals, habeas corpus does not apply. But even if it did apply, then you would have to find that the president had acted under a law that Congress had enacted. And that's clearly the case with the 1996 statute under this omnibus bill and the expedited removals. But the Supreme Court found that this doesn't apply. The suspension clause provides that, quote, the privilege of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. The court has held that at a minimum, the clause protects the writ as it existed in 1789 when the Constitution was adopted. Habeas has traditionally provided a means to seek release from unlawful detention. In this case, we're talking about removals, however. Respondents does not seek release from custody, but an additional opportunity to obtain asylum. His claims, therefore, fall outside the scope of the writ as it existed when the Constitution was adopted. So this kind of goes on, but Samuel Alito, and this is a 7-2 decision, I should mention, by the way. This is Alito, Roberts, Thomas, Gorsuch, Kavanaugh. Thomas filed a concurring opinion. Breyer filed a concurring opinion as well. Ruth Bader Ginsburg issued concurred as well. This was 7-2. That the suspension clause does not apply to the expedited removals. So you don't get to say, oh, like it's like an indefinite detention. But it could. They could have found that. They could have said, oh, yeah, the writ of habeas corpus. Maybe they would have found that it was suspended under the 1996 Act, and that therefore you'd have to go with that. Now, we do have, I have what is this? A Denver University Law Review looking at habeas corpus. The first proposal for its inclusion in the Constitution of the United States was made on August 20th, 1787 by Charles Pinckney, who sought to ensure that, quote, the privileges and benefit of the writ of habeas corpus shall be enjoyed in this government in the most expeditious and ample manner, and shall not be suspended by the legislature except upon the most urgent and pressing occasions, and for a limited time not exceeding a certain number of months. According to James Madison, all substantive discussion of the writ took place 1 week later at the end of the Constitutional Convention on August 28, 1787. And we have here the Madison debates. Here's August 20, 1787. He submitted his original provision for what becomes Article 1, Section 9, that the privileges and benefit of the writ of habeas corpus. His proposal that was submitted on August 20th, 1787. And then this gets amended by Mr. Governor Morris. Move that, quote, the privilege of the writ of habeas corpus shall not be suspended unless where in cases of rebellion, this later gets changed to when, or invasion, the public safety may require it. And then on that motion, New Hampshire was aye, Massachusetts aye, Connecticut aye, Pennsylvania aye, Delaware aye, Maryland aye, Virginia aye, North Carolina no, South Carolina no, Georgia no. So it was adopted. That's Article 1, Section 9, Clause 2 of the Constitution now, that eventually was ratified. And so the privilege of the writ of habeas corpus shall not be suspended unless there's an invasion. Public safety may require it. And the president, under the Alien Enemy Act, right here, can declare when there's such an invasion, and the president has so declared it, that there's an invasion of the United States by these criminal terrorist organizations. They're flooding the country with illegal aliens. They're engaged in human trafficking, sex trafficking, and millions of other people are coming here as well across the porous borders, overwhelming our system. Millions of people coming to this country right now. And the Supreme Court saying we can't remove them as alien enemies. So maybe we should just subject them to removals under Section 1182 of Title 8, inadmissible aliens under security grounds that they're terrorists, which is what the Attorney General stated at the press conference here, that's the basis for removal. So they want to say, oh, the Supreme Court wants to say, oh, don't do it under the Alien Enemy Act. Well, why don't we just, cut to the chase here? Let's do it under inadmissible aliens and under 8 U.S. Code 1225. That's going to allow for expedited removal of inadmissible arriving aliens, which the Supreme Court has already upheld 7-2. Here was Justice Alito on that. Every year, hundreds of thousands of aliens are apprehended at or near the border attempting to enter this country illegally. Many ask for asylum, claiming that they would be persecuted if returned to their home countries. Some of these claims are valid, and by granting asylum, the United States lives up to its ideals and its treaty obligations. Most asylum claims, however, ultimately fail, and some are fraudulent. In 1996, when Congress enacted the Illegal Immigration Reform and Immigrant Responsibility Act, IIRIRA, it crafted a system for weeding out patently meritless claims and expeditiously removing the aliens making such claims from the country. It was Congress's judgment that detaining all asylum seekers until the full-blown removal process is completed would place an unacceptable burden on our immigration system, and that releasing them would present an undue risk that they would fail to appear for removal proceedings. It concerns the constitutionality of the system Congress devised. Among other things, the IIRIRA, I'll just call it the Illegal Alien Act, placed restrictions on the ability of asylum seekers to obtain review under the federal habeas statute. But the United States Court of Appeals, Ninth Circuit, held that these restrictions are unconstitutional. According to the Ninth Circuit, they unconstitutionally suspend the writ of habeas corpus and violate asylum seekers' rights to due process. We now review that decision and reverse. Again, this was 7-2. Even Ruth Bader Ginsburg voted with the majority on this. Respondent's suspension clause argument failed because it would extend a writ of habeas corpus far beyond its scope when the Constitution was drafted and ratified. Indeed, respondent's use of the writ would have been unrecognizable at the time. Habeas has traditionally been a means to secure release from unlawful detention, but respondent invokes the writ to achieve an entirely different end, namely to obtain administrative review, additionally, of his asylum claim, and ultimately to obtain authorization to stay in the country. So looking at the writs of habeas corpus and then their suspensions, the one example we have to look at occurred during the Civil War, when Abraham Lincoln did this under a proclamation under September 25, 1862. It was establishing martial law. It was also stating that the writ of habeas corpus is suspended in respect to all persons arrested or who are now or hereafter during the rebellion shall be imprisoned in any fort, camp, arsenal, military prison, or other place of confinement by any military authority or by the sentence of any court-martial or military commission. This was eventually enacted by Congress March 3rd, 1863, an act relating to habeas corpus and regulating judicial proceedings in certain cases. That during the present rebellion, the President of the United States, whenever in his judgment the public safety may require it, is authorized to suspend the privilege of the writ of habeas corpus in any case throughout the United States or any part thereof, whenever and wherever said privilege shall be suspended, as aforesaid, no military or other officer shall be compelled in answer to any writ of habeas corpus to return the body of any person, etc., except by the or persons detained by him by authority of the president, but upon certificate under oath of the officer having charge of any so detained person is detained by him as a prisoner under the authority of the president. Further proceedings under the writ shall be suspended by the judge or court having issued said writ, so long as the said suspension by the president shall remain in force and the rebellion shall continue. After the Civil War, the statute was repealed. And then we can jump forward now to September 11th. I think that this is relevant to when the Congress enacted the statutes. I'm trying to find it here. It's a Patriot Act. We want the Patriot Act. The Patriot Act is when the Congress had. Is it over here? No, I had it pulled up. Under the Patriot Act, they expanded the terrorist provisions for inadmissible aliens. And I also have a law review article I wanted to look at as well. Well, let's see here. We'll just poke around here. Ready, reserve. There's the declaration. There's the inadmissible aliens. Here it is. Here's the effective date 2001 amendment. This is the Patriot Act, where they expand the types of terrorist organizations that can be deemed inadmissible. This, and this was done under the U.S. Patriot Act. Do we have that here? There's Duracium. There's an inspection. There's that. Is that it? Nope. Oh man, is this it? Nope. Patriot Act's here somewhere. Nope. Where is it? Patriot Act. Is this the law review article? Here we go. Here it is. Here's uniting and strengthening America by providing appropriate tools required to intercept and obstruct terrorism, USA Patriot Act of 2001. This was overwhelmingly adopted by Congress. Here's a Stanford Law Review article about this. Mandatory detention of certified aliens. Section 412 of the USA Patriot Act provides for the certification of aliens suspected of terrorist involvement and for their mandatory detention until removal from the United States. Under that section, the Attorney General may certify an alien if he has, quote, reasonable grounds to believe, quote, that, unquote, that the alien falls under any of the security-based grounds for deportation in the Immigration Nationality Act, 8 U.S. Code, Section 1182, or that the alien otherwise endangers U.S. national security. Under the Immigration Nationality Act, 8 U.S. Code, Section 1182, a non-citizen can be excluded or deported for national security reasons, including involvement in espionage, the attempted overthrow of the government by unlawful means, or terrorist activities. Now, any alien with whom the Attorney General believes is inadmissible or deportable under terrorism-related grounds of U.S. law, including the expansive new grounds in Section 411, may be certified under the USA Patriot Act. Even if an alien is not deportable based on these grounds, he may be certified if the Attorney General has reasonable grounds to believe that he otherwise endangers national security. The statute does not require the Attorney General to limit certification to aliens who are believed to be dangerous or pose a high risk of flight, or to make any finding to that effect. The Attorney General must take into custody any certified alien. While the decision to certify an alien invokes some discretion on the part of the Attorney General, that detention it triggers is mandatory. Within 7 days of detaining an immigrant, the Attorney General must place the alien in removal proceedings or charge him or her with a criminal offense. If no immigration or criminal charges filing, then the alien must be released. So I wanted to pull up this particular section, which is 8 U.S. Code, Section 1226A, mandatory detention of suspected terrorists. This is the alternative route to removal. Now, the president has said under the Attorney General that they're being removed under as Section 8 U.S. Code, Section 1182 as terrorists. That these are inadmissibles, and then you get the expedited removals that we saw under the 1996 statute. I've got a lot of jumping around here, but I believe I got all the correct statutes in front of us. Now, under the Patriot Act, they could do something different. They could say, we're going to indefinitely detain these terrorists, the MS-13s, the Tren de Aragua, and this was provided for under the Patriot Act. So this is an alternative route, and this would invoke the habeas corpus writ. The Attorney General shall take the alien into custody who's certified as a terrorist. And then you have a limitation on indefinite detention. An alien detained solely under paragraph 1 who is not removed under the section and whose removal is unlikely in the reasonably foreseeable future may be detained for additional periods of up to 6 months only if the release of the alien will threaten the national security of the United States or the safety of the community or any person. And the review of certification, the Attorney General shall review the certification made under paragraph 3 every 6 months. If the Attorney General determines in the Attorney General's discretion that the certification should be revoked, the alien may be released under such circumstances as the Attorney General deems appropriate, unless such release is otherwise prohibited by the law. The alien may request each 6 months in writing that the Attorney General reconsider the certification and may submit documents or other evidence in support of that request. Judicial review. Judicial review of any action or decision relating to this section is available exclusively in habeas corpus proceedings consistent with this subsection. Except as provided in the preceding sentence, no court shall have jurisdiction to review by habeas corpus petition or otherwise any such action or decision. So this really kind of limited what you could do under the Patriot Act. And I can get to this part of the Stanford Law Review article. The 6-month periods, only if such release of alien would threaten the national security. That limitation only applies to the detention of aliens who have been ordered removed, not to those awaiting the completion of deportation proceedings. The Attorney General must review an individual certification every 6 months and may decide in its discretion to revoke this certification and release the alien. In addition, every 6 months, a certified alien can request the government reconsider his certification and may submit documents or other evidence in his favor. Apart from petitioning for reconsideration, an alien can challenge his or her certification only through a habeas corpus petition, since Section 412 specifically limits judicial review to a habeas proceeding. This restriction applies to any certification decision made by the Attorney General or any decision made pursuant to the provisions limitations on indefinite detention. The statute does not elaborate on what claims specifically an alien may raise in a habeas proceeding. Habeas proceedings may be initiated in the U.S. Supreme Court, the District Court of Columbia, the District of Columbia, or any district court which otherwise has jurisdiction to hear it, while appeals may be filed only in the D.C. Circuit. Finally, Section 412 of the Patriot Act provides that the Attorney General must report to the Judiciary Committees of both houses twice a year on the use of that provision. So I think what we're led to believe is that the Attorney General could indefinitely detain the alien enemies and criminal terrorist gangs and just renew the certification every 6 months, hold them indefinitely, and under such determination. But under the order that the Supreme Court just issued, can't remove them as alien enemies. So again, I think that the president and the Attorney General have already moved on from the Alien Enemies Act insofar as they're just going to look at inadmissible aliens under security grounds and then utilize expedited removals under the 1996 Act that we covered in this video, that the Supreme Court has upheld 7-2 as being constitutional. Doesn't violate the writ of habeas corpus because although Congress obviously under the Patriot Act appears to have suspended the writ of habeas corpus for these alien enemies, because they can be indefinitely detained and, under the circumstances, renewed every 6 months. So Congress has suspended the writ of habeas corpus, and the Constitution provides for that. When there's a case of rebellion that occurred in the Civil War, we covered that. Where is it? Let's see, national emergencies, writ of habeas corpus. Here it is. Here's the 1863 statute that Congress enacted that suspended the writ of habeas corpus. And so if Congress wants to limit the judicial review of the terrorists under the Patriot Act, then it can do that. Of suspected terrorists, people who are in this country illegally or otherwise terrorists, then they've been deemed they're inadmissible under 1182, and you don't have to hold them indefinitely. You can just have them removed expeditiously, and that's what the president is doing. That's what the Attorney General is doing. So we'll jump back to my piece here. I think we've covered all of the statutes that we wanted to cover here. The 8 U.S. Code Section 1225 provides the Attorney General can remove the alien without a hearing. The Attorney General shall review orders issued if the Attorney General is satisfied on the basis of confidential information that the alien is inadmissible under the 8 U.S. Code Section 1182, and after consulting with appropriate security agencies of the United States government, concludes that the disclosure of the information would be prejudicial to the public interest, safety, or security, the Attorney General may order the alien removed without further inquiry or hearing by an immigration judge. Hear that, Supreme Court? Without further inquiry or hearing. But here we're still having hearings. All right. Well, let's just do it under 8 U.S. Code 1225. In sum, all that is necessary is that the Attorney General make the determination that the alien is inadmissible under security-related grounds, similar to the President's determination that there is an invasion and that there are invaders to be removed. These are solely executive branch determinations, or at least they were. 8 U.S. Code, Section 118283, are those aliens inadmissible on security and related grounds, including anyone who's been deemed to be a terrorist. Every year, and now here's where I look at the numbers on these expedited removals, the ones that the Supreme Court upheld in 2020. There's over 20,000 of them every single year. And we have this under information from the TRAC. What is this? This is the Transactional Records Access Clearinghouse. And this is U.S. Customs, Border, and Protection data. So here's track. Here's the total inadmissibles at ports of entry by disposition decision. You see here, expedited removal. Here's the number of expedited removals. 2014, 23,957. 2015, 25,967. These are without hearings. 2016, 30,346. 2017, 32,941. 2018, 30,988. 2019, 30,852. 2020, 21,578. 2021, 23,000. This is Joe Biden. 23,262. No hearings. 2022, 21,978. 2023. This is Joe Biden. 21,519. 2024. Again, Joe Biden. 21,998 expedited removals under 8 U.S. Code, Section 1225. That's the Supreme Court. Expedited removals upheld 7-2. Even Ruth Bader Ginsburg agreed that this was the case. But if you're going to do it under the Alien Enemy Act, whoa, says 7-2 Supreme Court, including Justice Gorsuch, Kavanaugh, Amy Coney Barrett, Roberts, and then the liberals. Only Alito and Samuel Alito and Clarence Thomas are like, wait a second, what the heck is going on here? And, you know, Justice Alito puts in a very good dissent, in my view. Hopefully the Supreme Court's going to overturn what they've done here. But for now, they've suspended all deportations under the Alien Enemy Act. In any event, these expedited removals that don't have any hearings, no due process, that had never been barred as a putative class by federal courts and certainly not by the Supreme Court until now. In his dissent, Alito stated literally in the middle of the night, we'll read it again, this court issued unprecedented and legally questionable relief without giving the lower courts a chance to rule without hearing from the opposing party within 8 hours of receiving the application with dubious factual support for its order and without providing any explanation for its order. Just cutting to the chase once again, the Supreme Court now appears to be holding the president and the federal government to the same standard of review as was being applied to the inadmissibles all these years. The ones who are being removed under expedited proceedings without any hearing, which admittedly is not much of a standard at all. After all, the attorney general need only say, hey, that person's a terrorist. Oh, Tren de Aragua, they're a terrorist. You're in Tren de Aragua, you get removed. Or, oh, you're MS-13, you get removed. You're Al-Qaeda, you get removed. You're Hezbollah, you're Hamas, you get removed. So these expedited removals have been going on for years and years and years, and nobody saw any problem. There was no suspension of or stay of expedited removals. In fact, the Supreme Court upheld the expedited removal. So I don't know what the problem here is. Why doing it under the Alien Enemy Act is different from doing it under the Patriot Act or under 8 U.S. Code Section 1182 and Section 1225, the 1996 statute. Just declared the president and attorney general no longer have power to enforce laws that Congress enacted to make such determinations. Every other president that AG was able to make without a hearing. What's good for the goose is good for the gander, right? It's very cute, you know. Yeah, so they're saying, oh, President Trump, you don't get a hearing to challenge the what we're trying to do, what the petitioners are trying to do in this case. We're just going to do it in the middle of the night. You don't get to argue against it. We're just going to do it. And Justice Alito covers that in his dissent. It's not clear that the court had any jurisdiction. It's questionable whether the applicants complied with the general obligation to seek emergency injunctive relief. When this court rushed to enter its order, the Court of Appeals was considering the issue of emergency relief, and we were informed that a decision would be forthcoming. This court, however, refused to wait. Under the court's rule, except in the most extraordinary circumstances, an application for a stay will not be entertained unless the relief requested was first sought in the appropriate court or courts below or from a judge or judges thereof. The only papers before this court were those submitted by the applicants. The court had not ordered or received a response by the government regarding either the applicant's factual allegations or any of the legal issues presented by the application. And the court did not have the benefit of a government response filed in any of the lower courts either. When the applicants first raised their allegations in the district court, that court provided the government with 24 hours to respond and was poised to rule expeditiously. But the district court dissolved the government's obligation to respond after counsel for applicants filed their hasty appeal, which in the district court's view deprived it of jurisdiction to rule. So here you have the Supreme Court in its order not providing the President of the United States the opportunity to argue why the Alien Enemies Act could be invoked or anything like that. It just said, stop all deportations under the Alien Enemy Act, which doesn't allow for judicial review except for residents. I think we've covered this in a prior video. Jurisdiction of the United States courts and judges under the Alien Enemy Act only applies to residents of the United States. An alien enemy resident, someone who lives here legally. That is someone who is not, someone who is not naturalized, they can just be removed. But somebody who is a resident, well, they would get a court, they would get a hearing in front of a judge. So someone who's a legal resident, someone who has a green card, they're from Venezuela, they have a green card, but Trump's declared that there's an invasion by Venezuela and Tren de Aragua. He's going to remove Venezuelans who have green cards. They would have to go before the judges because they are residents. And there was actually a Fourth Circuit Court of Appeals that actually tries to find that these are in fact residents. This is the Kilmar Abrego Garcia case versus Christy Nome. Upon review of the government's action, the court denies motion for an emergency stay. The relief the government is requesting is extraordinary and premature. While we fully respect the executive's robust assertion of Article 2 powers, we shall not micromanage the efforts of a fine district judge attempting to implement the Supreme Court's recent decision. It is difficult in some cases to get to the very heart of the matter, but in this case, it is not hard at all. The government is asserting a right to stash away residents of this country in foreign prisons without the semblance of due process. That is the foundation of our constitutional order. Further, it claims, in essence, that because it has rid itself of custody, that there's nothing else that can be done. This should be shocking not only to judges, but to the intuitive sense of liberty that Americans far removed from courthouses still hold dear. The government asserts that Abrego Garcia is a terrorist and member of MS-13. Perhaps, but perhaps not. Regardless, he is still entitled to due process. If the government is confident of its position, it should be assured that the position will prevail in proceedings to terminate the withholding of removal order. Moreover, the government has conceded that Abrego Garcia was mistakenly deported. Supreme Court's decision remains, as always, our guidepost. The decision rightly requires the lower court to give due regard to the deference to the executive branch with regard to foreign affairs. That would allow sensitive diplomatic negotiations to be removed from public review. It would recognize as well the facilitation of Abrego Garcia's return leaves the executive branch with options in the execution to which the courts, in accordance with the Supreme Court's decision, should extend a genuine deference. That decision struck a balance and does not permit lower courts to leave Article 2 by the wayside. And let's pull up the part about residents. Residents. Here we go. The government is asserting a right to stash away residents of this country in foreign prisons. So he's trying to say that Kilmar Abrego Garcia, who is ordered removed because he's here illegally, is a resident of this country. Well, if he's a resident of this country, then under jurisdiction, he would get a hearing. But he's not a legal resident at all. He doesn't have a green card. He had a withholding of removal to El Salvador. He can be removed to somewhere else. A withholding of removal is not residency. Residency is you are permitted to enter here legally. But the Fourth Circuit wants to say that the alien enemies are residents of this country, even when they've not even come here legally. Someone from Venezuela who came to this country legally could be a resident under the Alien Enemy Act, but not someone who's the invader. If you have an invading army and then they start occupying, Texas or New Mexico or California, and even if they stay there for 2 years, they don't become legal residents and then get court. They don't get a court case. There's an illegal invasion. You could just send the military in there and shoot missiles at them because they're occupying the country. Trump hasn't even gotten to an actual battle yet under his national emergency declaration on January 20th, where he put the U.S. military on the border. I think that, there could be actual battles, and we're not going to stop the battle to have a due process hearing. Can we deprive the alien enemies who are shooting at the military of their lives without due process? The Fifth Amendment does not apply to a military battle. So it can't apply to a military incursion, an invasion. It can't apply to a rebellion. And Congress knew this, and the Constitutional Convention knew this when they did the privilege of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. The Constitution, it is said, is not a suicide pact. Even the constitutional framers understood that in an invasion or a rebellion, you might not be able to do due process hearings. Now, at this point, in the Constitutional Convention, you did not have the Fifth Amendment yet, but this remains the law of the land. Article 1, Section 9 of the Constitution, Clause 2, never was repealed by the Fifth Amendment. So if Congress suspends the writ of habeas corpus, and you can argue they did that when they did the Patriot Act for the aliens, that you could indefinitely detain them, and you just certify that every 6 months. Yep, we're still detaining the alien enemy or the terrorists from Al Qaeda that we apprehended in Afghanistan or Pakistan or Iraq. We're going to keep on detaining them every 6 months. So we're to believe that you can detain the alien enemies or the terrorists or whoever indefinitely under the Patriot Act, but you can't remove them under the Supreme Court's order. I think that's absurd. They're not residents, Fourth Circuit. They can't be because they're invaders. So let's just jump back to my piece here. Here, the Supreme Court appears to be commandeering the enforcement of the border, who the executive branch determines to be a terrorist and who is therefore inadmissible into the United States. The border is not enforceable, quote, until further order of this court. So I say this is a constitutional crisis. If the court is truly determined to have 15 million hearings for every illegal alien, maybe the president should just bring every one of the soon-to-be hundreds of thousands of detainees directly to the Supreme Court and see if they can handle it. After all, that's where all these cases are going to wind up being appealed to. So just cut to the chase. The Supreme Court wants to say you get a Fifth Amendment due process hearing or a habeas hearing for every single one of the illegal aliens, whether they're an alien enemy, a terrorist, or just someone who came here illegally and they were looking for work or something. Yeah, let's just put them all to the Supreme Court if we have to. If there's no other way to, get this done. So again, the Supreme Court should see if they can handle 15 million cases, or if they're once again they're going to uphold the expedited removals as they did in 2020 in Department of Homeland Security v. Thracigium. I think that decision was fine, 7-2. Alito wrote this decision as well. And he actually Ruth Bader Ginsburg, she actually was with the majority on this. This was a 7-2 decision. You can do expedited removals. It's been upheld before. I don't know why it's not being upheld right now, and why the president is being forced to suspend the deportations under the Alien Enemy Act, except to say that he should just go ahead and do it under 8 U.S. Code 1225, expedited removals under the 1996 Act. Again, this is Robert Romano, Executive Director with Americans for Limited Government and Americans for Limited Government Foundation. Hit that subscribe button, ring the bell for notifications, and have a good day. But first, we'll go to the chat here. I suppose you're all angry at me, or maybe you're happy with me. We'll see. Well, we got lots of chats here, so we'll go through all the chats. from the tippy top here. Here is, let's bring this over here so I can see it better. Thomas Michelin, F SCOTUS. Yeah, the heck with them. Kathy Keaton. Seems to me Biden never listened to the Supreme Court. Trump should keep on deporting. Here's Stu Thompson. Technically, the Constitution is written for citizens of the United States. Therefore, non-citizens are not protected under it, and due process does not apply. Certainly an argument. Daryl Huber says they have overstepped their powers. Tab Betsworth, what can be done? I think I outlined some alternatives. If they're not going to allow the Alien Enemy Act to be invoked, then they should just do 8 U.S. Code Section 1225, expedited removals under the 1996 Act that the Supreme Court has already upheld. Dale Charnock, Mr. Trump, keep doing what you do. Mel Durrett, lots of support for President Trump here. Thank you, guys. Mel Durrett, classify all deportations need to know. So, yeah, I think actually they're citing security, national security, and we don't know how many people are being deported right now. Maybe keep it that way. Let the Supreme Court figure out how many there were later. Rob Scarrett, we have a constitutional crisis. We must push for a convention of states immediately. I mean, okay. I mean, do we need to amend the Constitution to provide that Congress has the ability to limit the judicial review of a writ of habeas? I mean, and Congress suspended the writ of habeas for aliens who are deemed to be terrorists in the Patriot Act. So Congress already did that. So they could just hold them indefinitely, or they can just deport them under the 1996 statute. You don't even have to go there. And the Congress clearly has the power to enact the statute that deems who's inadmissible, to provide for the expedited removals. And we know that because the Supreme Court already upheld it. So do we need a convention of the states? I mean, maybe to deal with the courts so that they don't have so much power, or they could just follow the laws of the land that they've already upheld. Ma Acock says, no. Judy Bresch Lurstang says Soros is paying them. Oh, gee, I hope not. Earl Shortridge, do say another word, just deport every last one. Don't say another word, just deport every last one of them. Yeah, there's lots of polling coming out showing that majorities of the American people, very substantial majorities, 55%, and some of these 56%, want to see all illegal aliens deported. And that's going to include all 15, 20 million of them. I mean, at best, you could maybe deport like 300,000 a year or you could do expedited removals under the 1996 Act. Why don't we do the expedited removals? Because otherwise it could take decades to remove all of the illegal aliens that Joe Biden let in here. Jay Keith, way overstepping the judicial, their limits. They are to interpret laws. They're supposed to say what the law is. I agree with that. And make sure they are constitutional, not tell the executive branch how to run the branch. I agree with that. Here's Penny M. Cordar. That includes Democrats' so-called shadow government, in which they are attempting to stop a duly elected president, to thwart the will of the people that elected President Trump. I agree with you. Here's Penny Cordar again. How is it that the Supreme Court is working against the U.S. Constitution? I think that's a great question. That's what Sam Alito wants to know. Jerry Brown, tyrants, lock all 7 that voted for it up. I don't think we want to do that. Jenny Robinson, what the heck is going on with the Supreme Court? This is like a unanimous decision by the chat. The Supreme Court is wrong. Brandon Miller, so far, all of these people deported already had their hearings and had deportation orders. But either way, it's the president's job to defend our borders, and they can deport anyone they deem to not be here at any time. These judges are overstepping their authority. Here's Bonnie C. Sattler. Evil within. Here's Paul Henderson. Brandon Miller. The judges should be arrested and charged as co-conspirators. William Johnson. These judges will be the ones that destroy America. Cheryl Depew. Guess it's time to fight the Supreme Court. Dennis Michael, remember the Nike ad, just do it. All right. And here's Loyola Mary. Voters, do not take your eye off any member of your family. The Democrats and any corrupt judges are determined to let these drug cartels and criminals take over America, allow them to rape, murder, and push their drugs. Peace will never happen, but the hate and violence of the Democrats will be our way of life. Voters, our choice, peace or Democrats' hate and violence. Thank you for your comment. Sincere Servant says, WTF? Yeah, what the heck's going on here? Randy Hamilton, our courts must be overhauled and revamped. The Constitution is clear on which branch is to oversee our borders and illegals with deportations. If you come here illegally, already a gang member, and commit crimes, you have no rights under our Constitution and deserve none. The court should never interfere with immigration and deportations. Throw those cases out. You represent U.S. citizens only. Thank you for your comment, Randy. Here's Buck Skidmore. Yeah, that's not happening. Trump will declare martial law and arrest all of you corrupt Democrats and Republican patriots will help. Hope we don't go there. James Bolton. What less to expect from globalist puppet, God-worshiping, racist Democrat criminal judges appointed by globalists to preach globalist agendas? John Moss says, Trump, you are our president and you have the power. We did not elect some of these judges. Deport them at the ones that did not want to even register. And John Moss says, maybe it's time for term limits on the Supreme Court. Well, they serve during good behavior. That's thought to be lifetime appointments. That's certainly what the framers thought. You can read some of the Federalist Papers on that. They thought they were doing lifetime appointments. So I'm not certain that's the solution. But I've gotten through all the chats here, and we have a unanimous verdict from the chat. The Supreme Court is wrong, and President Trump is clearly under Article 2 of the Constitution as the president in charge of enforcing border security and can remove everyone who is here illegally. And I covered all of the statutes that Congress has enacted that agree with that position. So Congress is, pretty uniform in this. We had these expedited removals since 1996. We've expanded the grounds for declaring terrorist organizations. And President Trump has so declared them under laws that Congress has enacted. He's otherwise militarized the border. He's put the ready reserve out there, up to 1 million members of the military. And he's declared under the national emergency that he declared on January 20th. And so I think President Trump is good. Just keep up the good work, Mr. President. We've been going on for over an hour here. So this is Robert Romano, Executive Director with Americans for Limited Government and Americans for Limited Government Foundation. Thank you for tuning in. Hit that subscribe button, ring the bell for notifications, and have a good evening.